Good morning and welcome to the Big Buzz Breakfast Club. We're so glad that you could be with us today. We are super excited to have our guest today to help us ring in the new year and double check if your nonprofit is compliant for 2025 with the employee laws that are in place. Just a few notes today. We will be recording this session and we will be sharing it with our participants afterwards. And do put any questions in the chat. We will be happy to answer those as they come up. And please, by all means, if you need to adjust your closed captioning settings, please feel free to do that. For those of you who may not know me, I'm Melissa Legowski. I'm the founder and CEO of Big Buzz Idea Group. And we know that many nonprofit executives lack the time, staff, skills, and the funding they need. So Big Buzz Idea Group fills in gaps to help nonprofits focus on the big picture and position your organization to thrive. We offer the Breakfast Club on the second Thursday of every month, and we are always trying to bring you topics of interest and relevance to help you run your organization better. We also just want to mention that as we turn the corner into 2025, we do have a program that is a mastermind for nonprofit leaders. It is called the Power Cell, and it is meant to be a safe space where the same group of 3 nonprofit leaders can come together regularly on a monthly basis to talk about issues, brainstorm solutions, and just have a place where you can come and feel like you can get honest answers from people you can trust. So we will be launching new groups in 2025, and we would love to have you participate. Now, on to the reason we're here. We are super excited to have Eileen Lysaught present today from Laner Muchin. She is an employment law attorney and she has been practicing in this space for many years. I'm very fortunate to have known Eileen for many, many years. Hard to believe how many, they add up quickly. But we are super excited to be able to have her with us today to talk about employment law. One of the things that I know we were talking about before we got started today is the fact that, this is one of the first times that I recall seeing where the government is really setting us up. And for months, everybody's like, get ready for this change, get ready for this change. And on a few different fronts, they've said, well, no, we're changing our mind in the 11th hour as we're about to turn the corner into 2025. So I think that this topic couldn't be more relevant. I think there couldn't be a better time for this. And we are super excited to have you with us, Eileen. I'm going to turn it over to you if you want to bring up your slides and take it away.
Yeah, give me 1 second so that everyone gets to see my technological skill set here. And that is not what we want. There we go. Okay. Does that look good? Okay, and I am sharing. Okay, great. So good morning, everybody. I want to, there we go, give you a list of the things that we're going to be talking about today. The first one is actually a federal regulation. And then the second one is, the second set is a group of state and local laws that are here to stay. They're not going to be deemed to be unconstitutional. So let's get started. And before we start, I wanted to note that closer to the end of this presentation, we're going to talk a little bit about the National Labor Relations Board. Most of you probably believe that it doesn't apply to you. Most people think of that associated with unions. But the reality is the National Labor Relations Act and the board do apply to non-union employers. So we'll give you a little quick update about them. Okay, so the first thing we're going to talk about today is the Fair Labor Standards Act. Most of you guys are familiar with this. Your employees are either called exempt or non-exempt. You're really talking about the Fair Labor Standards Act, FLSA for short. Overtime for folks in Illinois, it's 1.5 times their regular rate. if they work over 40 hours a week. The exemptions are generally executive, administrative, and professionals. And to be exempt, you actually have to meet a two-part test. So you can be an executive, an administrator, or a professional, but if you make less than $684 a week, you're not exempt. So you have to meet the salary requirement and the duties test. And everyone was all in a bundle earlier this year about increasing salary levels. And so what you probably did or may not have done is on July 1st, 2024, you may have had to increase some of your employees so that they met the new requirement. So it jumped from $684 a week to $844 a week. And then lo and behold, in November of this year, this proposed regulation was overturned. And so when that happened, the increase that was supposed to go into effect January 1 of 2025, which was going to again double the salary threshold from $844 a week to $1,100 a week, was found to be unconstitutional. And when the court did that, it actually said, well, it's not just the January going forward, because there was another one in 2027 and another one 3 years later. They said the one in July 1st of 2024 was also unconstitutional. So now we are back at $684 per week as our salary threshold. So even though we had to go through all that crazy last year, and before the court actually found it unconstitutional, it probably was a good thing for most of us to go through our records to make sure we were actually classifying employees correctly. If you haven't done that, I would suggest that you audit to make sure that you've classified your employees, first of all, that they're making the correct salary, and secondly, that they actually meet the definitions of executive, administrative, or professional. You know, law firms are pretty easy. Lawyers aren't covered by it. So then we only have to look at our staff. But that, unless you're a law firm, that doesn't help you very much.
Can you talk
yes.
just a little bit about the duties test for people that might not really be well versed in this and may not understand that, just any kind of additional information around the duties?
Yeah, give me 1 second. So the first, I'm going back to this slide because it lists the duties. So what we're going to talk about are the duties for executive, administrative, and professional. Those are 3 separate categories. And so for executive, the employee's primary duty has to be managing the enterprise or managing a customarily recognized department or subdivision of the company. The employee must customarily and regularly direct the work of at least 2 or more full-time employees. And then the employee must have the authority to hire or fire other employees. Their suggestions or recommendations as to hiring, firing, advancement, promotion, or any other change of status must be given a certain level of weight. So if you manage 2 or more employees, but nobody's going to listen to you if you want to hire, fire, whatever, you don't meet the requirements. So you'll see a lot of people that have manager titles, but they really don't manage anything. That's not going to cut it. So then for administrative, the employee's primary duty has to be performance of office or non-manual work directly related to the management or general business operations of the employer or the employer's customers. And the employee's primary duty includes the exercise of discretion and independent judgment with respect to matters of significance. So while most, and I'm just going to say legal assistants because that's what I do, most of them have a fair amount of discretion in the way that they run their jobs. I ask my assistant to do something, they do it, comes back fabulous. I don't have to give them any instruction on how to do it. But that independent judgment that they're utilizing, even though it's significant to me, it's not significant to the firm. So they don't meet that test. So you really have to look at each job to see if it meets the requirements. It's sometimes if you have 5 or 6 employees and they're all basically doing the same thing, you can look at the position. But you may also have different people that do different things within that role that could make a change for one person versus another. So then professional, employee's primary duty is the performance of work requiring advanced knowledge, defined as work which is predominantly intellectual in character and which includes work requiring the consistent exercise of discretion and judgment. Advanced knowledge must be in the field of science or learning, and the advanced knowledge must be customarily required by a prolonged course of specialized intellectual instruction. So a good example of that would be like an engineer. So engineers are typically considered professionals. Even though it's a 4-year degree, it is really, you and I couldn't do it if we wanted to, unless we went and got an engineering degree. My son's an engineer. I couldn't do it even if I went and tried. So we all have our positives. So does that answer your question, Melissa?
Absolutely. I think that helps give some framework for people who might not be as familiar with the terms. Thank you.
Right. And if somebody has a question about someone, they can just give me a call. Okay, so go back to the basics. Are your employees classified properly? Look at the day-to-day tasks that they do. Analyze whether or not their salaries are correct. And then if you find that you think you have a couple people that you may have misclassified, then I would reach out to your employment attorney to discuss how you might want to correct that. In Illinois, if you need to make a salary change, you need to give them written notice of the salary change before it goes into effect. And salary changes, as we all know, can really affect culture and morale. So it's something that should be discussed. So I am going to try to do all these slides in an hour. And so I'm going to talk fast. Melissa, if I need to slow down, slow me down. So in the Illinois Equal Pay Act amendments, Illinois has been putting amendments in fairly regularly. So 2003, you can't have pay disparities based on sex or race. At that time, it was actually on race was just African American, and now it's much broader. January 2019, the salary history ban. You can't ask a job applicant to disclose their pay or their salary history. You can ask them what they're looking for or what they want, but you can't say, how much do you make right now? So don't do that. Then in March of 2021, for private employers that have more than 100 employees, they had to file an equal pay registration certificate with the Illinois Department of Labor. There are people that miss that filing. And really, there is no way to update that filing. So it has to be updated every 2 years. So I think the next window is going to be March of 26. So I'm going to, that only affects people with more than 100. So it's big companies that they were trying to get some information on. And then January 1 of 25, the new pay transparency requirements go into effect. And that means that employers must provide pay and benefit information on specific job postings. And I have to apologize, this slide says all employer, and it's really only employers with 15 plus employees. So an employer with 15 or more employees must include the pay scale and benefits for any position that they are posting, let's say through Indeed, or even on your website if it's outward facing. So you can either put the information directly into the ad, or you can put a hyperlink in the ad that goes to a different page that lists for my manager position in Chicago, I'm going to pay a range of a minimum of $15 an hour up to $23 an hour, and the benefits are going to be this. So, excuse me. You can do the hyperlink as long as the information for that position is on the hyperlink. If you just put kind of a general, I pay between $15 an hour and $100 an hour, depending on the job, and you might have some benefits, but I might take them away, that isn't going to cut it. You have to make sure that if you give the link to, let's say, Indeed, that they actually utilize the link. There are record keeping requirements. It's about 5 years. I can't go into like all the nitty gritty in a webinar like this, but just keep that in mind. And then once you have that posted, well, first of all, if you don't do this, you're going to have a problem. So first, fine, you're okay. It's like $500 and they give you 2 weeks to cure it. But then it starts going up. So put the information in the ad. I think, you're going to be the one person out there that doesn't have it. So it's going to be pretty easy to see that you've got an issue. And I think you will have less people responding to your ads, because if the people can see the data and your ad doesn't have it, why are they going to go through the hassle of applying for you? Just because you list a range in your ad doesn't mean you need to hire someone if you have a very good basis for going outside that range. So here's a little graph to kind of go through the flow chart of what you need to do. So first of all, you need to have 15 employees. If you do, then is the specific job position posted externally? Yes. Okay. Then you need to follow the pay transparency requirements. Then the next question is the position a promotional opportunity for any of your existing employees? If it is, then you also have to provide notice in-house to all your employees within 14 days of the posting. If it's not a promotional opportunity for any of your employees, let's say it's an entry position that none of your other employees would be interested in, that you've just newly created, then you don't have to post it in-house. If you have less than 15 employees, you don't have to bother with it. If the job is not posted externally, you don't have to have pay transparency until you have a candidate that asks about it. So if you're going through the interview process and a candidate says, what's the salary, what's the benefits, you do have to provide them with that information. Now, there are 4 classes of systems that kind of get around the Equal Pay Act. If you have a seniority system in place, generally that's seen in manufacturing environments, union environments, things like that, or a merit system. Everybody does reviews, and your reviews very clearly note that X person goes above and beyond, and so there's some sort of written justification of why that person gets to be paid more. Similarly, their work quantity or work quality is better when you're comparing the 2 people. That can justify a pay differential. Differentials other than sex and race, and you should be okay. If you're using sex and race as a differential, you and I should be having a completely different conversation. So I think we talked about this.
Oh, we have a question in the chat about what
Okay.
about a second language?
You get a little tricky with that. So if part of the requirement is that a person is able to speak Spanish such that they can provide service to a broader range of, let's say, consumer service people. And it's an extra requirement, then you can actually pay them more for that requirement. But you have to be very careful that someone that has learned Spanish that may not be a native Spanish speaker is also very welcome to interview and have the opportunity for that position. So you don't want to make it race-based. So I speak Spanish, but I would get my face slapped probably because it's not acceptable professional Spanish. So you wouldn't want to hire me because my skill set isn't where it needs to be. But if I've taken 6 years and I lived in Mexico at some point and whatever, and I had the skill set, then the job should be open to me. So hopefully that answers your question. So different pay transparency requirements apply to different size employers. So the unequal pay for unequal work is 4 employees or more. The wage and salary inquiry, same. Pay transparency jumps to 15. Promotional opportunity, which is where you have to post it internally once you've posted it externally. If it's a promotional opportunity, 15, and then the equal pay registration is 100 employees. So again, we call these toolkits. These are things you should be doing or should be reaching out, to an employment lawyer to have them help you with, do you need to do a pay audit to make sure that your wages are being paid appropriately across all sorts of different requirements? Are your job descriptions where they need to be? Are you doing performance reviews, and do they list out objective criteria that could lead to differentiations? Are you doing employee training on the importance of making sure that there isn't discrimination within your pay structure and your review structure? And then having internal policies. You can have pay plans. You can update make sure your record retention policies are updated so you're keeping the appropriate records. And then make sure your third-party vendors, like Indeed, are actually doing what they have to do legally now if you have more than 15 employees. So the Illinois Wage Payment and Collection Act is also being amended. And what it's now requiring are pay stubs. Most of you probably give pay stubs to your employees, whether it's digital or physical. Some of you may not. And then you can look at providing them something that works as a pay stub. So pay stub means an itemized statement or statements reflecting an employee's hours worked, rate of pay, overtime hours, and then gross wages, deductions made from employee wages on that paycheck, and then also year to date. And then I also add on for our Chicago and Illinois employees that you also need to list out how much leave they have available, whether it's sick leave, paid leave, PTO, whatever you happen to call it, and how much the employees utilized. Record keeping requirements. You have to retain pay stubs for at least 3 years from the payment date. And the employees now have a right to inspect their pay stubs within 21 days of a request, and they can do it twice a year. you should have some sort of request form to make sure that you're handling them the same for everyone, and that you have an actual record that they requested it. So if you provide electronic pay stubs, like let's say you use one of the big payroll providers, Paycom, ADP, I don't know, there's a million of them. And your employee still can access that system once they've moved on, like that you've terminated them, they've resigned, whatever, that's acceptable. If they can't access that, then when you're terminating them, or preferably a little bit before you're having those discussions with them if they've resigned, you have to offer them an opportunity to review their pay stubs. So you want to do that in writing, you want to get it dated, you want to get it signed, and they would need to tell you if they want their pay stubs, if they want them in a physical format or a digital format. And you know, if we don't follow those, then we get fined by the Illinois Department of Labor. So I'm going to suggest that you prepare documentation, a pay stub review form, an acknowledgement of the pay stub receipt. So if you give them to the employee, you should have them sign off that they actually received them, so you have some proof of that happening. Update your record retention policies so that you're retaining the records for the appropriate period of time, and then train your HR folks, especially if they're the ones responsible for offboarding or exit interviews for people, so that they know that that's something that they have to ask about, and they can get the correct forms and the sign-offs as part of their normal process. Okay, if I'm hoping everyone's still awake. I know this is a little bit dry, and I apologize. I'm giving a customer service presentation next week. It's much more lively, but this is the law and there's not much I can do about it. So Illinois Personnel Records Review Act, most of us are familiar with that. If an employee asks to review their personnel file, they have the ability to do that twice a year. You let them look at the file. They can, you can arrange something in your office. Now it's broader. So effective January 1, 2025, employers with 5 or more employees, the employee has the right not only to inspect, but they can also copy and receive the documents. So, and it's not just their personnel file anymore. So it is copies of any handbooks that were potentially relevant, copies of any written policies that you contend, let's say they were terminated, you contend applied to the termination. Any employment contracts or any agreements that may or may not apply to them, like a non-solicitor, a confidentiality, or a non-compete in very limited circumstances in Illinois. And then let's say you use an outside company for ADA, disability accommodations, FEMLA, Family Medical Leave Act. If you're a bigger company and that applies to you, you have to request the records from them to provide to the employee. So you didn't have to do all that before. If you have employee handbooks, now when you update it, you need to make sure you keep copies of your old ones, because if somebody's been with you for a while, they have the ability, that's a document that you may apply to them. So it doesn't have to be in their specific personnel file, but it needs to be available for you to compile as a part of their personnel record to produce to them upon request. So we suggest that you actually have a written policy that speaks to this process. You identify who the employee needs to request, make the request to. If they make it to someone else, your other employees should know that it has to come to the right person, because you have a very limited time to actually respond to an employee's request. You can request that the request be in writing, but that includes text and email. So I would set up a policy that if you you work for Melissa and you say, hey, Melissa, I want to look at my personnel file. She says, great, I'm going to give you this form. Please fill out this form and get it back to me. And that's the way we start the process. There are fines. The Department of Labor can allow an employee to file a lawsuit if you don't give them the right documents. Have the written form, and it should specify what personal records they want. You know, they may not want their whole file. They may just want a handbook. They may just want the write-up that their employer just gave them. And so what do you want? Do you want the whole file? Do you want just a part of it? Do you want just to see it? Do you want us to copy it? And then who do you want us to send it to? So we're not just giving it to the employee now, we're also giving it potentially to a family member, to a friend, to their lawyer, so they can specify who they want it to go to. I'm going to suggest if they're saying they want it to go to a lawyer, that you get on the phone with an employment attorney and number one, make sure that you're getting them everything you need to be getting them. You're getting it to them within the required time frame, and what you're producing is stuff that you have to produce. Because if you don't have to produce it, then I wouldn't be producing it. You have 7 days to respond. So it's a really short time frame, especially if you need to be getting records from somebody else. And then you have one time, if your request is reasonable, to get another 7-day extension. So we want to make sure we've trained our HR staff that there are these new requirements. And you're going to want to make sure that you update personnel records and files timely, so that if a request comes in, everything's in there and you're not having to cull through email and anything else that'll slow you down.
Eileen, they are asking in the chat to confirm that this is for any sized employer, correct?
Yeah, 5 or more.
5 or more. Thank you.
I should know that off the top of my head, but there are so many of these and they all have a different number, just to make sure, just to keep us on our toes. But if, let's say you have 4 employees, start getting all your ducks in a row, because it's going to happen and you're going to be crazy, and all of a sudden you're going to be at 5 and you're not going to have the procedures in place.
The other thing I think about a lot of this too, Eileen, right, is that it is also best practices. So even if you only have 2 employees, I mean, some of it, why not go ahead and do it? You know, it sets up a better relationship. It gets you prepared for the future, for any changes that might come. Because I know, like with the retirement plan, right, it just kept dropping down until you got to the smallest fish in the pond. So I think it's just a lot of best practices too.
100%. And if you start out doing it right, then you don't have to have a oh darn moment where suddenly you're playing catch up, especially on a regulation like this where you only have 7 days to respond. None of us need that level of stress in our lives. So just to be efficient. Okay, so this regulation probably doesn't apply to a whole bunch of people, but I need to go through it in case it does. So E-Verify is a system that companies can use to make sure that the employee that they are onboarding meets the requirements to work within the United States. And what the Illinois Department of Labor has done is, first, the regulation is written horribly. So when it first came out, everyone was looking at it. And that's, of course, my opinion, not Laner's opinion. is it looked like they were saying that no one in Illinois could use E-Verify. And I've used E-Verify before. It's actually a very helpful program. But that's not what they were saying. So they have since clarified in their frequently asked questions that if you choose to use E-Verify, then you have to follow these requirements if you're an Illinois employer. So you have to make sure that the folks that are using E-Verify are trained appropriately. E-Verify provides online training. So you just have to use the Department of Homeland Security's computer-based training. And then the US Department of Homeland Security also has a notice relating to E-Verify that you need to post. So if you do that before July 1st of 2025, so at least they give us a little bit of a window, or within 30 days of enrollment. So if you're already using E-Verify, then you have until July 1st. If you just sign up for E-Verify now, then you have 30 days. You can violate this regulation if you fail to post the required notice, if you don't get your folks trained, and you don't put protections in place so that your employees are sharing their passwords and their information, which is bad enough with this, but if you're allowing employees to do that, you've got bigger issues with data breaches and cybersecurity and all that kind of stuff. So don't let your employees use other people's IDs and passwords ever.
Eileen, going back just a second to the personnel files, I had not seen this question pop up.
Yep.
But if you have an exempt high-level employee that has been having performance issues and you're keeping informal notes, do those need to go into the personnel file?
Are you going to use them as the basis for letting somebody go? Probably.
Waiting for a reply. If you want them, so let's assume you do want to use them to be able to dismiss an employee.
Right. Then I would put them in the file. And I wouldn't make them informal notes. I would make them, this employee did this thing wrong. This was reported to me. I mean, why would you not want that in the file? It doesn't mean you have to keep it in the file every single day, but make sure you know that you have that information. So if that employee requests the file, it's available. And hopefully before you terminate that employee, you're having sit downs with them so that none of this information is going to be a surprise.
And then following up on that, right? I know that when I've worked in more formal organizations, if there was a discussion, that then there was also always a place where the employee signed that there had been a discussion. I assume that's still a best practice, correct?
It is, and half the time the employee won't sign it because they don't agree with it, whatever. It doesn't really matter. If they've been presented with it and you have that in your records that you sat down with them, you can sign it, employee refuses to sign. I always say best practice is training all your managers on how to, and executives, like up all the way to the top, on how to do reviews, and not once a year, like literally sit down with your employees, meet with them every 2 months or something, and have that conversation. This is going great. This isn't going great. This isn't, so that it's not once a year where you're dumping on somebody about, you could have done these 17 things better. That doesn't do them any favors, and it doesn't do your company any favors, because now you've lost a year of potential productivity. So
I think in that example, it's also really hard sometimes to remember specific scenarios, and sometimes the
100%.
details on either side can be very useful. So I always think that real-time discussion is definitely something to aim for if there are issues.
Right. So my background is I used to be an executive in a manufacturing company, and I used to run HR departments. So before I came in-house as an attorney. So, and you learn how valuable having an open and honest review program is, because then you don't have employees that are freaking out when they're having to be let go, because they know it's coming and they have had opportunities to actually fix it versus being blindsided. So sorry, I digress. So back to the fun life of E-Verify. If there's a discrepancy in work authorization documents based on what you're seeing from E-Verify, you have to give the employee notice of this. So you're going to tell them the specific documents at issues. You're going to give them within 7 days of the issue being discovered. You're going to have to now give them instructions on how to correct the discrepancy. And then if you have a union, if you have a relationship with the union, you have a collective bargaining agreement, there's something called a memorandum of understanding that you may have with the union that specifies certain things. So if you have an MOU, memorandum of understanding, then you have to give them an explanation of rights that they can have representatives available at your discussions with them. Some of you may get these SSA letters. So they're letters from the Social Security Administration. They generally say that your employee's Social Security number is either not theirs, or there seems to be a discrepancy because, you know, two people are showing up with the same Social Security number. And I have heard historically that lots of people just ignored those because they don't say you have to do anything, but the reality is you really shouldn't be ignoring those. So best practice on those, and now under Illinois, it's really best practice. You can't take adverse actions. Just because you get one of these letters, you can't be like, oh, you're fired, that your Social Security number's not right. So you're going to go through a process with them where you're going to re-verify that their numbers are right. And you can't say, bring in your Social Security card. You have to be like, we've got this letter from the SSA. It's saying that there's something wrong with your Social Security number. We're going to need to get this resolved. We have to provide notice within 5 days, and they can have a representation, a representative available in those meetings of their choice. So it can be a fellow employee, it can be their spouse, it can be whoever they want it to be. So if in fact something like this comes up, I would suggest you speak to an immigration attorney. Like my firm has an immigration attorney and they specialize in this. I would not personally give advice on this because there's nuances that I just don't run across on a day-to-day basis, whereas an immigration lawyer does. I can tell you about it, but I won't help you through it.
Eileen, I have another question. So when we are talking, right, about the whole E-Verify, so that is equivalent, I think, to the I-9 traditional verifications of an employee. Is that right?
Nope.
They're different.
It can be used. So I-9 is an employee verification. So generally, you send the employer the I-9 or you show the employee the I-9 and you say, bring in some of these documents from these different groups, and they bring in their driver's license or a passport or whatever they bring in. That's fine. You can do that, and you still have to do that for everybody you onboard. Some employers, especially big employers that have lots of people coming in and presenting, they use E-Verify to verify that the information that they're being provided, it matches what the government has. So I've personally used E-Verify because I oversaw a manufacturing plant in North Carolina where we had lots of employees coming and going, and we wanted to make sure that we weren't running afoul of DHS. So I never used it personally, but the company that I worked for used it. And my understanding is that the employees run the Social Security and the driver's license or whatever through the E-Verify system, and then they get information back from E-Verify that it either matches the records or it doesn't.
Great, thank you. And then we have a question in the chat going back to the last topic on reviews,
Okay.
especially if discussing poor performance issues with the supervisor. Is it advised to have the HR person or another witness present? What is best practice?
So if you know in your heart of hearts that this is going to go south, and you're going to let this person go, I would suggest having someone else there. It is a big flag to whoever you're sitting down with, if that is not part of your normal practice, that this is the direction that this is going. So if you're getting ready to let go an executive, I would suggest you talk to an employment attorney so that they have all the information in front of them and they can guide you on best practices in getting it to where you need to go, so that by the time you're making that termination decision, you have everything that you need. Because at an executive level, they're more likely to get an attorney involved. So if you're dotting your I's and crossing your T's early, then you're going to have less of a freak out when their lawyer reaches out to you at the other end. And you might want to consider severance just as a protective mechanism. I generally call those cheap insurance policies. Not so cheap, but insurance policies. And I'm sorry, my office is very green, so I haven't moved enough apparently. And my light just, there we go, sorry.
Yeah, no, thank you. I hope that we have not taken you too far off course, but I think all of this is really good. I know a lot of organizations are much smaller, and I just don't know that training in these areas has generally been shared. So I think it's so valuable. Thank you.
Right. Okay, so I'm gonna try to, I have no idea what time it is. Hold on a second. Oh, 10 minutes. Okay, so IHRA is the Illinois Human Rights Act. There are amendments, and this really relates to you can't harass, you can't discriminate against folks now for family responsibilities. And it doesn't mean you don't have to offer accommodations for family responsibilities. You don't have to lower their performance, conduct, or attendance standards. But you can't discriminate because somebody has family responsibilities. And family responsibilities are actual or perceived. Personal care to family members. Personal care means medical, hygiene, nutritional, safety needs, providing transportation to medical appointments. Personal care can also mean physically present to provide emotional support to a covered family member with a serious health condition. So I think what they're trying to do here is really combat stereotypes, especially against, young mothers, maybe young single mothers, that where you're interviewing a woman. Of course, you can't ask if they have kids, but you find out that they have kids and you're like, oh no, she's going to have to be doing all these mom responsibilities, so I'm not going to hire her. Well, you can't do that. So family members include child, stepchild, spouse, domestic partner, sibling, parent, mother-in-law, father-in-law, grandchild, grandparent, step-parent, pretty much everybody. So if you have an employee that has these sorts of responsibilities, they're worth talking about. If you can accommodate them, fine. You don't have to. You just can't make job choices based upon these sorts of things, like anything else that's considered discriminatory. So sex, race, marital status, veteran status, now family responsibilities falls into that same protection. And so does reproductive health decisions. So this regulation, I think, was put into effect to protect abortion rights. So And I think it's one of many bills that was introduced to try to do that. So you can't discriminate against an employee because of their reproductive health decisions, which includes contraception, assisted reproductive technologies, miscarriage management, termination of pregnancy, and then prenatal, postnatal care. And I'm really sorry, you guys, we've got like 10 minutes, so I'm trying to get through this. If you have questions and I can't get to them, submit them to Melissa. She can submit them to me and I'll try to get you an answer if we can't get them done before the end of today. So the Illinois Department of Human Rights used to have a deadline of 300 days for an employee to bring a claim against you. It has now been extended to 2 years. So EEOC is still at 300 days if there's a state regulation or a local regulation that governs the same topic. Otherwise, it's 180 days. So I'm not going to go through all this. So the AG, the Attorney General, now has a right to file suit, and they can get all up in your business, that's a legal term, and file subpoenas against you if someone reports that you are discriminating or harassing them, and the AG seems to think there's a common practice. And the penalties can be rude. So up to 50,000 for first-time violations, 75,000 for repeat violations within 5 years, 100,000 for multiple. So they just they're trying to stop discrimination and harassment. You do not want the government in your business. Another amendment to the Illinois Human Rights Act is about artificial intelligence. This doesn't go into effect until 2026. You can't use AI in hiring, promotion, training, discharge, discipline, tenure, employment conditions if the AI causes discrimination. So you'll hear a million people, especially my age, who say they're out looking for a job and they're not getting responses. They're not even getting through the application process because they're getting screened out. If the system that you're using is doing that, it's discriminatory in action. So even though it may not be developed to be discriminatory, if it's discriminatory in effect, that's a problem. So other things that apparently folks were using to screen out people that they didn't want working for them were zip codes. Like, those are bad zip codes, bad people live there. We're going to put those in as not being a group that we're interested in, which is mind-boggling to me. But so don't do that. And if you're using screening tools, talk to your vendor and make sure how the AI is working so that you're not walking into a mess. Make sure they know how their software works. So ways to make sure you're okay and you meet the new Illinois Human Rights Act amendments: update your handbooks and your policies, update your harassment and discrimination training to address reproductive health and family responsibilities, review any technologies, and train your HR and management folks. There are 2 regulations affecting digital voice and likeness. If your business creates digital replicas of people, talk to your employment lawyer to make sure that you've got the right consents in place. Illinois Right of Publicity Act, same sort of amendment. If you're going to be using people's likenesses and you're going to make digital, whether or not you're making digital replicas, but the digital replicas is what the new amendment, you need to have consent to use their images, likeness, voice, for any sort of commercial purpose. Whistleblower Act, Don't retaliate. That's just so make sure you have a process in place to investigate not only claims of discrimination and harassment, but also claims that somebody's doing something funny in your company. So if an employee comes to you and says your accounting person is skimming money off the top, you of course want to investigate that. I would suggest if you get a claim that's that level, reach out to whoever your attorney is, have them get involved to make sure that the investigation is done right. And then, because you're gonna want to report back to the employee, if you find that it's 100% legal, whatever anybody's doing, you know, letting them know that you appreciate them coming to you, that they're not going to be retaliated against for coming to you, the results of your investigation, so they know you didn't just blow them off, is good. Illinois Worker Freedom of Speech Act, captive audience. You cannot require your employees to come to a meeting that talks about religion, that talks about politics, or talks about what you think of unions, the not positive things that you think about unions. You can't do that anymore. So some of that's Illinois Worker Freedom of Speech Act. Some of that is the National Labor Relations Act. I have 3 minutes left. Illinois did update their child labor laws. If you're hiring anyone under the age of 16, your process has probably changed in making sure they can work for you. So reach out to an attorney just to dot I's and cross T's to make sure what you're doing still complies with the law. And there's pages of this. So there's a new employment certificate. There's always been an employment certificate requirement, but there's changes to it. The hours that they can work, there's changes to. And there used to be a park district exception. I don't know if any of you guys are park districts, but I can give you the rundown. Different meal breaks, they have to have supervisors. And if they are injured or God forbid killed, there's new reporting requirements. Illinois Biometric Information Privacy Act has been updated. It's actually to employers' benefits now because the damages were crazy, and now recoverable damages have been limited so that no one wants to get into biometric litigation, but it's less scary than it used to be because those damages generally aren't covered by insurance. So if you're going to track any of your employees for anything, and it's going to use their fingerprint or their blood or their voice likeness, anything like that, you have to get their consent. Especially a lot of the time clocks that people use, you need to have biometric consents for, FYI. Secure choice savings for folks with at least 5 employees, you have to have a 401k option available. Illinois provides an option. So if you haven't heard anything about that and you have the right number of employees, please reach out to someone to make sure you can get a plan in place. So 5 employees, been in business for 2 years or more, and you do not offer some sort of retirement plan. They added Space Force to the definition of armed forces. So if you have any employees working for the Space Force, we should talk. And then I am not going to go into the NLRB because I think we are finished. Let me see if you're going to have a severance agreement and the person is under 40 and not a manager, you can't have confidentiality language in it anymore. or non-disparagement clauses, because that violates the NLRA. Okay, so
Eileen, I know that we are at time, so I appreciate very much. I mean, so much good information, and I know that this is stuff that nonprofits are just not generally guided through. They're not usually trained on this in places that I've seen. I will be happy to continue to share if people have questions, if people want to get in touch with Eileen, as she mentioned, simply let us know. We will send follow-ups today as well and include Eileen's information. But she's just a wealth of knowledge, as you all see. And I hope everybody walks away with some great information and learned a lot that they can apply immediately, because I think so much of it is very applicable. And thank you so much, Eileen. We really appreciate you being with us today.
thank you.